Imagine this, you're driving through Norfolk after a casual evening at home. You feel fine, completely confident that you're okay behind the wheel. But here's where it gets tricky. Virginia law might see it very differently. Today, we'll look at why so many DUI cases hinge on field evaluations that most people assume are routine, harmless, or purely scientific. And, well, what happens during those tests could completely change the legal outcome, without you realizing it. Here's the counterintuitive legal fact misconception. Most people think a DUI only happens when a breathalyzer or blood test shows THC above a certain level. Legally true, yet operationally misleading. In Virginia, you can be charged based solely on observed impairment during roadside evaluations, even without chemical confirmation. Here's one belief most of us likely hold. So you might be thinking, well, if I smoked last night, I'm safe by morning. That sounds straightforward, but, legally speaking, impairment isn't strictly tied to timing or dosage. It's about observed effects, officer discretion, and procedural interpretation. This is where most drivers stop learning, and where legal trouble quietly starts. Welcome to the Norfolk, Virginia Cannabis Hub, where we focus on Virginia-specific cannabis law, local governance, and regulatory clarity, so residents, business owners, and communities understand what the law actually says, not just what headlines suggest. Today we're breaking down how field evaluations influence cannabis DUI outcomes, why they're legally complex, and what enforcement patterns reveal about real-world application. We're keeping this educational and compliance-focused, no promotion, no lifestyle framing. We'll explore the statutes, enforcement practices, and real scenarios so you can understand the law and its practical implications. Here's the context. Virginia legalized cannabis possession for adults in 2021, but driving rules remain strict. Unlike alcohol, where clear BAC limits exist, cannabis DUI cases rely heavily on field evaluation, officer observations, standardized sobriety tests, and sometimes oral questioning. Confusion is common because THC metabolizes differently than alcohol. Observed impairment can vary dramatically between individuals. Law enforcement has wide discretion under Section 18.2 to 266 of the Virginia Code. Let's talk about the legal explanation. Under Virginia law, driving under the influence of any controlled substance, including THC, is illegal. Key statutes. Section 18.2 to 266, driving while intoxicated. Section 4.1 to 305, controlled substance definitions. Impairment isn't strictly chemical. Officers evaluate balance, coordination, eye movement, and verbal responses. Chemistry, labeling, and packaging matter, but they're secondary to observed behavior. Let me rephrase that. THC presence in your system doesn't automatically prove impairment, observable effects do. That distinction, behavior over biochemistry, is critical. So how does enforcement work? So let's ask ourselves, how do these charges actually unfold? Enforcement typically involves patrol stops triggered by driving behavior, field sobriety tests, walk and turn, one-leg stand, horizontal gaze nystagmus, observational notes on speech, demeanor, or coordination. Lab reports can help, but they're not determinative. An officer's testimony often carries more weight in court, especially in the absence of an elevated THC blood level. This is where timing, officer training, and procedural consistency change outcomes. Who does this affect? Consumers, even responsible, occasional users can face DUI charges if field evaluations suggest impairment. Employers, hiring or driving policies may intersect with DUI records. Local governments, police practices vary. Norfolk and Hampton Roads officers may apply evaluations differently. Medical cannabis patients, law doesn't exempt patients, symptoms and observed impairment still guide enforcement. Why this matters? So let's take a moment to unpack why this is really important. First, public safety relies on accurate evaluations. On paper, a field sobriety test seems simple: step, turn, balance, but in practice, small differences in execution or observation can have major consequences. Imagine two drivers performing the same walk-and-turn test, one is flagged, one isn't. That tiny variation can mean the difference between a safe road and an accident, or in legal terms, between a dismissed case and a DUI conviction. And, well, that's exactly where most people stop paying attention. Next, regulatory clarity affects prosecution consistency. Virginia law provides the framework, but enforcement varies city to city, even officer to officer. Norfolk officers may emphasize certain cues, while a nearby jurisdiction interprets the same behavior differently. That makes outcomes unpredictable. So yes, technically, the law is the same across Hampton Roads, but how it's applied? Legal and financial risk is high. Fines, license suspension, court costs, those are just the beginning. A DUI can ripple into insurance premiums, employment eligibility, or even eligibility for certain professional licenses. And it's not just the immediate penalties, because a conviction creates a record that interacts with federal regulations, background checks, and long-term financial planning. Small legal distinctions, like whether the officer documented slight imbalance or clearly impaired, can literally change your financial trajectory. Long-term policy implications are significant, too. Judicial precedents in these field evaluation cases influence future enforcement patterns and legislative updates. One case in Norfolk can subtly affect how officers are trained, how prosecutors evaluate evidence, and how judges weigh field observations in Hampton Roads courts. So, even though it might seem abstract, every minor detail has a ripple effect across the local cannabis DUI landscape. Now, let's pause here. Most people stop at statutes and say, okay, I know the law, I'm fine. But understanding law versus application? That's crucial. Field evaluations aren't just tests, they're interpretation tools. Officer discretion, procedural adherence, and evidence timing all determine whether a charge sticks. And, well, this is where many assumptions about safe driving quietly fall apart. Here's a scenario. Earlier, I mentioned that impairment evaluation could make or break a case. So let's walk through a real-world style scenario. You're driving in Norfolk at 7 a.m. after consuming cannabis the night before. You feel fine, you're confident. But the officer notices minor swerving and signals you to pull over. At this point, the field evaluation begins. First, the walk-and-turn test. Step 1, heel to toe, a slight wobble. Step 2, turn, perfectly okay. Step 3, return, small imbalance noted. Speech? Clear. Lab results? Later, they show trace THC, well below typical impairment thresholds. Now here's where things diverge. Outcome 1, the officer testifies that the observed wobble constitutes impairment. The judge, weighing the testimony alongside procedural notes, finds sufficient evidence for a DUI conviction. Outcome 2, another officer in the same situation might interpret the exact same performance as normal variation. Case dismissed. See, this is exactly what we mean by layered uncertainty. On paper, you might think you're safe. Legally, THC presence isn't the only factor. Procedurally, officer interpretation matters more. And practically? Minor details, the time of evaluation, the officer's training, how notes are written, change everything. Here's what to watch next. In the next video, we'll explore how Norfolk officers' training in cannabis impairment differs from surrounding cities, and what that means for consistency across Hampton Roads. You'll see why cases can swing dramatically depending on local enforcement culture. Here's a question to think about. Have you ever assumed THC presence is the only factor in a DUI? How might observed impairment and officer discretion complicate that assumption? Drop your thoughts respectfully in the comments, and tell us what Virginia cannabis law topics you want covered next.